All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Title IX, looking backward at the Educational Amendments Act of 1972. This is the fourth installment of our educational law series, and with this webinar, we're going to wrap it up. But before I introduce our speaker, I'm going to go ahead and go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive a copy of the recording via email from Zoom within 24 hours. We're also going to be posting it on YouTube, so you should, if you're subscribed to our channel, you should receive the notification shortly, or you can just check out our YouTube channel later. The training was approved by the Florida Bar for 2 General CLE and 2 certification credits for education law. I'll announce the CLE code at the end of the session. I will also drop that CLE code into the chat, and I will also include it in the email and the YouTube description. So let's see. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to drop the link to their website into the chat so that you can take a peek. I'm going to also drop some links to their social media accounts so you can check them out. Final piece of housekeeping announcements are questions and answers. If you have any questions throughout the presentation, feel free to use the Q&A feature. You will see that we have a lot of content for today, so we'll hope to answer all the questions towards the end of time permits. So without further ado, it is my pleasure to introduce our speaker today, Dr. Beverly Brown. Dr. Beverly Brown is a passionate legal advocate and lifelong educator with extensive experience in educational advocacy and Social Security appeals for children with disabilities. A former Equal Justice Works Fellow at Three River Legal Services, Beverly has presented students in due process, Section 504, and ADA matters across 17 Florida counties. She now provides pro bono services through Southern Legal Counsel. Beverly also has a rich background in teaching and program development and remains committed to empowering children through individualized advocacy. So, without further ado, I'm pleased to pass it over to Dr. Beverly Brown. The floor is yours.
Thank you, Jorge. Good afternoon, everyone, and welcome to our final class for the educational series. We appreciate the platform and the opportunity to obtain education-related credits. So today we're going to cover Title IX, and it's entitled Looking Backward at the Educational Amendment of 1972, which was reauthorized in 2020. Then there were amendments made in 2024, which we will discuss toward the end of the presentation today. And then the changes that were made by an executive action that came in 2025 when President Trump was placed in office. And here's part of the language of the executive action, which changed anything that was to be read as gender prior would be read referencing sex, consistent with this executive order, which was written and signed in January the 20th, 2025. So in covering Title IX, it's just kind of a massive non-discrimination act for controlling federal funding in educational areas. And I covered or tried to cover everything that you needed to know about Title IX, which led me to the development of many, many slides. So I probably will talk rather quickly, but I hope that it will be beneficial and we'll cover everything that you need to know. So we begin by talking about Title IX's interplay with other laws that already exist, a brief legislative history, the regulations that guide Title IX, what federal financial assistance is, how it's defined, and how it's used, who the recipients of that can be, what are covered educational programs, discriminatory contact, what is sexual harassment, and then how will Title IX be used in a facility that is receiving federal financial assistance. So the procedural guidelines for compliance with Title IX, how that will be enforced, whether there is a private right of action once there is enforcement. Does the state have immunity from enforcement? And then, as I mentioned, in 2024, under President Biden, there were many changes made to the 2020 version of Title IX. Then the executive order was signed, and all of the changes that were made in 2024 were removed. So the version of Title IX that we are using now is the 2020 version, with the executive order changing gender to sex. There's some recent cases at the end, but most of the cases were generated as a result of the 2024 amendment, so are moot in nature for the most part due to the changes in the law. And if we have time, we will address questions. So beginning with the interplay with other laws, the laws that Title IX has built off of are Title VI, which is a law that deals with racial discrimination and on the basis of race, color, or national origin. Section 504 of the Rehabilitation Act of 1972, which deals with discrimination against individuals with disabling conditions or with disabilities. Title VII, which prohibits employment decisions discriminating on the basis of sex, race, color, or religion. And then the 14th Amendment, or the Equal Protection Clause, more specifically, of the 14th Amendment, which makes it unlawful to treat individuals differently in situations where there is funding from the government. So Title IX controls federal funding of educational programs. It doesn't apply to situations where there are single-sex admissions policies. So those programs would be exempt, like the Boy Scouts or YMCA. They give examples where there are the specific sex is part of the requirement for that individual program. Also, some educational operations are funded by religious organizations, and if it's inconsistent with the religious tenets of that particular religion, for them to involve both sexes in a program, then the religious tenets would be followed. So that's just kind of a broad overview of Title IX. Moving on to the legislative history. In the 70s, there was a push for equality for women in the workplace, and that became a focus of inequity in an educational setting. So in 1972, Title IX was drafted and passed to confront the inequities between the sexes in the educational environment. And in 1974, it was amended to include sports. In 2024, it was broadened to discuss or to use the term sex instead of gender, and this created enhanced protections for LGBTQ individuals and pregnant students, and a lot of litigation. So moving on a couple slides. The amendment to Title IX included the Civil Rights Restoration Act. So any part of an entity receives federal financial assistance the entire entity must comply with the civil rights law. So under Title IX, if any part of the entity receive federal financial assistance, so let's say a prison received educational funding under a grant, then a grant from the government, then Title IX requires that discrimination protections occur throughout the prison, and all operations that are covered by Title VI and 504 and education and training would be covered by Title IX. Agencies that receive federal funding assistance, such as Health and Human Services and the DOE, if it still is an agency, and the Department of Agriculture and the Department of Engineering or Environmental Department, these agencies would have to promulgate regulations in order to use Title IX and to comply with Title IX within their agency. So what does federal financial assistance look like? Well, like I mentioned, it could be grant money, it could be use of a federal property, it could be some sort of federal training situation, or it could be a loan of federal personnel. If federal government provides resources, these resources can be either direct or indirect. Direct resources are just that. Those are going to be financial assistance that is provided directly to the facility. Indirect might be provided to someone that is a private person, and they then receive the assistance through a voucher, certificate, or a coupon. So for example, if someone receives a voucher for childcare, that would be indirect assistance. And not federal financial assistance would be, just to give you examples of things that are not, would be like licensure or money for a mortgage lender, or paying for federal training, not when you're provided with the federal training. So if someone receives federal financial assistance, who do we then consider as the recipient of that assistance? Well, it's the public or someone at the state, not someone from the federal agency. It may be more than one person. It can be a successor, a transferee, or an assignee. So it can be somebody who is a third-party recipient of the financial assistance, or they might receive it directly. So the direct acceptance of federal financial assistance, triggers responsibilities under Title IX. And they provide you, or here are some examples of what this direct financial assistance looks like. Within a law school, a university has federal grants, loans, and interest subsidies in excess of $7 million from the DOE. They're considered a recipient. The U.S. Department of Justice is providing for vocational education for inmates in a prison. So they are considered a direct recipient of federal financial assistance. And the police department in a city that's receiving a community outreach program from the DOJ would also be considered a direct recipient. So then what is an indirect recipient? These would be situations where somebody might be bound to somebody else. So for example, as in the prison situation, we may have hired someone at the prison to be a contractor and they are teaching welding. So the person who is getting the training in welding is an indirect recipient of the federal financial assistance. But both the prison and the contractor are bound by Title IX. And educational programs that accept this federal financial assistance are bound by the constraints of Title IX. There's a case cited on the next slide. It's Jeldness versus Pierce in the Ninth Circuit. And this case summarizes there were 6 prisons in the jurisdiction, and 5 were for women, and 1 was for, 5 were for men, and 1 was for women in the jurisdiction. And all of the prisons offered different types of vocational programs. So the women didn't have the same access as men, and there was a suit filed claiming discrimination because women didn't have the same access to the vocational programs that men had access to in the prison system. And women also claimed that men were being paid as a result of their participation in the educational programs or the vocational programs, and women were not. And this was discriminatory. And the court held that it was discriminatory not to pay the women, but that the differing vocational options didn't rise to the level of discrimination, because women could travel to the vocational options and there were different options available at the different prisons. Okay, moving on. Discriminatory conduct prohibits exclusion or benefits from a federally assisted educational program. So if somebody is found to have participated in discriminatory conduct, they have excluded somebody from the benefits of a federally financially assisted educational program. And there are 3 types of prohibited discrimination. These you will see in the other acts that built, the other titles and acts that built onto this act. Disparate treatment, disparate impact, and retaliation. And administrative enforcement is what you will see to enforce all of these, what is used to enforce all of these. So what is disparate treatment? Disparate treatment is when you're treated differently because of sex, which is a decision that the complainant is aware of, that you have made. It seems like an intentional decision, but even if it's not, regardless of motivation, if you have treated the complainant differently because of their sex, it is disparate treatment. To prove discrimination, they use Title VII burden shifting framework, which was established in McDonnell-McDouglas Supreme Court case, the Douglas Court versus Green case. It raises an inference of discrimination. So to establish the prima facie case, you would have to, 1, say that the aggrieved person is that the aggrieved person is the is in a protected class. So is the aggrieved person initially in this protected class? And have they applied or are they eligible for a program receiving federal financial assistance? So they're in the protected class, they've applied and are eligible for this program, which gets federal financial assistance. Despite eligibility, the person who is rejected is rejected. So we have a rejection of someone who is eligible. The program is still open and accepting applicants, and the recipient selected applicant has the same qualities as somebody else who's applied who's of the opposite sex. So those are what you would need to prove up discrimination under Title IX. And then the recipient, as a defense, would state the real reason for discrimination, and you would have to determine if that is a pretext. So is it not true? You can also show a pattern of discrimination in that an educational facility might have discrimination that you see as a standard operating procedure, that they normally treat these protected class members in this way. It's just their pattern of treatment. And if you can show that, then you can make the inference that other protected members of that class would also be treated in that discriminatory way. And disparate impact results in consequences. So if you have disparate impact, you have a causal connection between a neutral practice and a disproportionate and adverse impact on a protected group. So you have individuals who are dealing with discrimination because of their placement in a protected group, even if it isn't an intentional act. Substantial legitimate justification is similar to the concept of business necessity. If you have discrimination in an educational setting, there has to be substantial legitimate justification. And the recipient has to show, the recipient of financial assistance has to show that it was necessary for them to meet that goal, that educational necessity was occurring. On the next slide, there's a disparate impact case that's Sheriff versus New York State Education. It's a case where it discusses how there are fewer inferior services and provided for individuals because of their sex. And in this case, it's women who were competing with men for scholarship positions based on the SAT, and reliance on the SAT scores, which I was not aware of, was women score lower on SAT scores than men, and the women were discriminated against in this situation because the only test that was required was the SAT. So in this case, where you have a situation like that, where a test that's obviously discriminatory is being employed, if they used another measure that was not discriminatory, such as the ACT, there wouldn't it wouldn't have the same disparate impact. And so a substantial legitimate justification, if it's identified and alternative policy achieves the desired outcome. For example, in this case, when I mentioned the ACT test and using it instead of the SAT, you have more balanced outcome. So in that case, the substantial legitimate justification identified would be using a different test. A right exists where there's a mechanism for enforcement, and if someone thwarts that right, it can be a violation. If someone is thwarting your right, it can be looked at as retaliation, and retaliation is also something that is prevented or discussed as blocked by Title IX. Elements needed to establish retaliation: you need a complainant that's engaged in protecting their rights under Title IX. You need recipient knowing of the protected activity. You need a recipient that's subjecting the complainant to adverse action, treatment, or conditions, and you need causal connections between adverse actions and protected activity. So that would establish retaliation. And then moving forward, to establish a prima facie case with merit in retaliation, you would need to show that the recipient's offer is reasonable, show that there's reasonable pretextual reasons, and that there is a sufficient show of it's sufficient to show retaliation. And courts have also found Title IX prohibits employment discrimination. Title VII also addresses employment discrimination. When researching employment cases under Title VII and the EEOC guidelines and 29 CFR Part 1604 and 1607 would be used for employment practice. So if an entity has Title IX forced upon them, that they are in a situation where federal funds are being accepted and somebody is the recipient of these federal funds, if they do not want to comply with Title IX, they can decline the federal funds. They still might be in a situation where they're subjected to Title VII, and they might have a narrow exception, which they have called the bona fide occupational qualification, or the BFOQ exception, which is an exception of needing someone to be of a specific sex. For example, a female locker room security personnel or a male locker room security personnel. Somebody who is their sex is specified for their position. So what are the provisions that can be violated under Title IX? There can be treated different for an aid or benefit. An individual can be seen as different in the manner they're treated. They can be denied an aid or benefit. They can be subject to different rules or inconsistent rules. They can apply a rule to their eligibility to the domicile, or they can aid or perpetuate discrimination. They can limit a person's enjoyment or rights. They may not discriminate on the basis of housing, but need to assist those that they have targeted for assistance. So, for example, if they are seeking to work with single mothers, then they obviously are not discriminating when they only are funding individuals for this housing situation who are female. So if in their grant application they have specified the sex that they are targeting, then it's not seen as discrimination. Other specific provisions, there may be separate bathroom facilities under the current reading of Title IX for individuals based on sex, but the facilities have to be comparable. So what does that mean? They have to be equal in nature. The facilities have to be the same. A prison might offer different courses. We mentioned that with the case that we discussed briefly earlier. But the equality of access has to be there, and the programs have to be comparable. There shouldn't be different materials used to assess the sexes, but if, like we mentioned earlier with the SAT, if there's a biased assessment, then you might need to use a different type of assessment to measure something, to remove bias or eliminate bias. And you must ensure that the criteria for eligibility for and amounts are as equal as possible when you're dealing with financial assistance. If employment is offered, it has to be offered to both, like was also mentioned in the earlier case, in a non-discriminatory manner. If you're going to be providing health benefits to students in an educational setting, there need to be protections like you would offer in an employment setting. Pregnancy-related absences should be subjected to the same policy as temporary disability. And I think these are some things that we'll be talking about in a few minutes that changed in 2024 but have changed back. Among special provisions, there's still no discrimination and participation in athletics. You're allowed to have separateness in contact sports, and they're identified in the 2020 version of Title IX. The contact sports are boxing, wrestling, rugby, ice hockey, football, basketball, and other sports where major activity involves bodily contact. And then they address textbooks in a special provision, but it's nothing about textbooks is actionable under Title IX. Moving on, also, as well as sexual discrimination, sexual harassment is addressed under Title IX. Sexual harassment is to treat someone differently, to provide different benefits, aid, services in a different manner, to deny aid, benefit, or services, to provide separate rules or sanctions, to significantly assist somebody and not someone else. All these things in a manner that discriminate. And if a recipient finds that they have discriminated, they need to take remedial action to overcome the effects. So it's something that they should do upon themselves, but they might have to be told to do so if they don't realize that it's happening. The conduct that constitutes sexual harassment are the same for both Title VII and Title IX. But to be liable for money damages under Title IX in private litigation, you have to be faced with actual knowledge of the discrimination and be deliberately indifferent. If a recipient is aware or should be aware that sexual harassment is occurring, they must take remedial steps to eliminate it, the harassment, prevent the harassment, and remedy the effects of the harassment. Title IX also works to prevent sexual harassment by employees, program participants, and it identifies that harassment can occur by same-sex individuals. And there's a whole section under Title IX about gender harassment, which identifies gender harassment, basing it on sexual stereotyping as one type of gender harassment. If harassment occurs off the premises, and so if a federally funded institution has harassment that's occurring off premises, an example of that could be like in a museum where they've gone on a field trip away from the museum, it would still be actionable against the museum because it was part of their program. The same thing would be true for internships if they occur in another setting. If it's determined that corrective action needs to occur, then it needs to happen in a timely and a reasonably appropriate way. So there's an impetus on the person accepting the federal funds to deal with the harassment that's happened and try to remedy it to the extent possible, or make corrective action if you want to continue to receive funds. It's also being encouraged to develop a policy to prevent things from being discriminatory, or to prevent discrimination and harassment. So an individual policy that's outside of Title IX procedures. And then once you have your policy, there are many procedural requirements for complying with Title IX. So the implementing procedures are outlined in 34 Code of Federal Regulations 106.4 through 106.9. Those are the implementing regulations for compliance. One of the first things that the applicant must do is submit written assurances that they will comply with Title IX, and you probably are familiar with that if you have worked somewhere where you have to comply with Title IX. You're probably familiar with that if you're involved in grant writing. The funding agency will designate what the assurances have to be like, and in the assurances, you will need to let them know how you're going to comply with Title IX, the implementing regulations, and if there's remedial action for existing discrimination. So if you if there's discrimination that's currently occurring in your place of work or your educational institution, then you're going to identify it and share that information with your assurances. Title IX requires that if you're an educational institution, that you conduct a self-evaluation to comply with their rules. But this only is if you're an educational institution. So if you are a prison or a museum and you have an educational component that requires complying with Title IX, you're not considered an educational institution. But if you're a community college or you're an elementary school, then those would all fall under educational institutions, and they would need to conduct self-evaluations. To the extent that you don't comply with Title IX, you need to indicate in your self-evaluation how you're going to modify them to bring them into compliance, how you're going to take steps to remedy discrimination, how you're going to keep records of your assurances and modifications, and you're supposed to keep these for 3 years, and they're supposed to be provided upon request from anyone who wants to see that you are being compliant. You have to also notify the public that you don't discriminate and that you are under provisions of Title IX. You have 90 days after you've applied for the financial assistance. You need to publish this in any kind of publication. So once you've received or are a recipient of the funding, excuse me, once you're a recipient of the federal funding, you need to publish in any kind of publication that occurs for your institution or in a memorandum or a public letter. And then in any memos that come out following that, you need to make it clear that there's notice of compliance with Title IX. Once you've received the funding and you are a recipient of federal financial assistance as an educational institution, you have to have a Title IX coordinator. A Title IX coordinator is an individual responsible for complying with all of these regulations that come under Title IX and for dealing with complaints that can be filed to your agency. The person who is the coordinator needs to provide their name, address, and phone number to all the employees. So it needs to be open to everybody who uses the system. And you must adopt and maintain a grievance procedure. The Department of Education actually has published a grievance procedure, and I think I sent Mr. Acosta a copy of it weeks ago, but if not, I can download it and send it again quickly to your materials for this class, because there is a grievance procedure that is recommended. So there's no sense in reinventing the wheel. If you're receiving federal funds and you have to comply with Title IX, you have some sort of educational institution, this grievance procedure that has been established by the DOE is probably quite helpful. I'm not sure what happens when the DOE no longer exists, but there probably will be a record of the document somewhere. A failure to have a grievance procedure is not a right of action. So if you do fall under Title IX's protections and you don't have a grievance procedure, it can be enforced administratively. but you don't have to have an in-house grievance procedure. The funding agency providing financial assistance to you is responsible for enforcing Title IX. Title VII procedures are applied. So whatever that funding agency is, it might be, maybe it's Human Health Services, maybe it's the Department of Justice. Whoever's funding you, though, is going to enforce Title IX by looking to see that you are compliant and have been compliant throughout your time with this funding agency. The agency standard of liability is different from a court. They have an affirmative duty to correct even if there's no monetary damages awarded. So in the situation with agencies and agencies providing assistance, if they hear of retaliation or disparate impact or discrimination, they have a duty to correct, even if it doesn't rise to the level of some sort of monetary damage award. The pre-award procedures, I've moved through a few slides. I'm sorry, I'm just trying to make sure we get it all in. The data that's needed pre-award to actually get the funds over time is to note all of the complaints that have been received and have a description of all the assurances or pending assurances with applications, have a descriptions of all of the complaints that have been reviewed, and a statement of whether the applicant has been found not compliant. So you have to maintain a certain amount of data throughout your compliance, or once you receive federal funds, this is part of it. You have, once you are finished with the award, and maybe when you're seeking another year or when it's the end of your compliance review, you would show evidence of any violations. You would show if there's been satisfaction of inspections, and you would show that there was, if that satisfaction was pursuant to an administrative plan. So were the violations determined, a plan was developed, and then compliance was achieved once the plan was reviewed and followed. All of that information will be shared post-award compliance review. The types of issues that are typically targeted: those individuals who are ID'd as problems, those who are from a certain geographical area that don't have agency presence already, issues that are ID'd by advocacy groups or grant recipients. So sometimes you have groups of attorneys like Hills who have identified issues that are key and out there, or sometimes civil rights agencies have identified issues that should be targeted. But all of those things would be issues that could be looked into with compliance reviews. And when you're developing complaints within an agency system like this, they're typically prompt. They look to hold it within a narrow window of time. So the statute of limitations, usually 180 days or something thereabouts. Frequently they will look to extend the time frame for the complaint if the issues are related that you're pleading, but the standard for extending the time frame is hard to meet. You must have a complaint with merit. You have to notify all the parties in writing of the violations. The agency will seek voluntary compliance and enforcement if necessary through judicial action or administrative fund suspension. So if the agency hears that these things have happened and they've reached out and they're seeking to get things fixed, if they're not finding that things have improved, they can seek to have the federal funds suspended or seek enforcement through judicial action if they go that far. You can refer to another agency if it's required because it's outside of this agency's jurisdiction, and frequently if you file something with an agency, so for example, you file with the Department of Education and they find that the claim you filed is really a Health and Human Services claim, then they frequently will send it to the other agency. But if not, they will let you know that the other agency is responsible. You have to be wary of duplicative compliance. So if you're in a situation where your area is funded by more than one of the agencies, then you may have to, or you will have to, if there's more than one, share your compliance information with more than one agency, and you may delegate your enforcement responsibility. So you might be sharing and delegating your enforcement responsibility as well. There are only 2 agencies that have delegation agreements currently. At least these are the only 2 that I found. NASA and the Environmental Protection Agency currently have delegation agreements, and there is a movement to create a Title IX and Title VI interagency delegation agreement to include the remaining federal agencies that don't have delegation agreements. So I think that will take care of this piece over time. If there are complaints filed against the educational institution, you have to maintain a log of these complaints and specify and just some bare minimum things like, the sex of the person who is involved in the complaint, the date, when it was filed, when was the investigation completed, the date and nature of the disposition, and any other information that would be pertinent. The federal funding agency methods to enforce the complaint, and we kind of touched on these, but to begin with would be to resolve by voluntary means. So they try to fix things in-house. Secondly, and this would probably be a lot more difficult, would be to stop the funding. So the federal funding would no longer occur, and that would be harsh. And then a referral to the DOJ for judicial action, which would stop the funding if it hadn't stopped already. So if you are consulting with a federal agency or state or local agency by passing on those areas that are non-compliance to those people who are complying, you would agree to voluntarily comply, and you would bypass those areas that those agencies or non-federal agencies that aren't compliant. So to comply, you may have to work your way through the agency or work your way through the institution. Some portions of the agency applicant might be recalcitrant. They might not want to comply. So there's advice about voluntarily complying and trying to reach as many non-litigation alternatives as possible. The next slide refers to the DOJ authority to sue in federal court, and the authority for Title VI and Title IX is by any and other means authorized by law. So in that case, we're discussing actually filing this in federal court because you have jurisdiction under this authority by any and other means. The referral to the Department of Justice happens in the following manner. Your funding agency must first determine that a violation exists before it can be referred. So you have to go through the agency process of determining that there's a violation. The recipient is notified of the failure to comply. The funding agency then initiates the referral to DOJ. So DOJ referral process isn't automatic, and it's something that has to be initiated by the funding agency. Within the funding suspension process, it begins by a notice, a departmental hearing, or a finding within the department. The head of the agency can suspend the actual funding, and the head of the agency can file a report with the House and Senate legislative committees. So that's the process that has to be gone through for suspending governmental funding. The agency can fund their termination limited to the particular political entity or part thereof that discriminated. So just to the portion of the educational entity that discriminated, so that all the funding is not terminated. And an individual under the Supreme Court has a private right of action under Title IX, Title VI, and 504. So how do we get this right of action? If you have, you are a recipient of federal funding assistance, and you haven't been able to rectify the issues yourself. You had intentional discrimination, and you seek judicial relief, and you can show that the damages were monetary, or you're seeking monetary damages, then that's how you have a private right of action. There is some discussion in the slides about having no right to sue in federal government, but there's some case law that allows you to bring an action against the agency. And if there is a private right of action, you can bring the action in federal court if it's intentional discrimination. Frequently, an injunction is brought That's the most common form of judicial relief. An injunction is when you're asking them to cease and desist the discriminatory behavior. Also, if there's an intentional violation, and if you're familiar with administrative law, you frequently have to exhaust administrative remedies and not under Title IX. If you're entitled to intentional violations or monetary damages based on an intentional violation, you do not have to exhaust administrative remedies. Those monetary damages are available for intentional discrimination if you can prove that. Okay, so there are several slides I'm going to kind of just skip through. There's a Franklin case, which you're welcome to read on your own. The availability of monetary damages, thank you, Jorge, of monetary damages and other circumstances, they may not be available when it's unintentional discrimination. If we establish it had to be intentional discrimination, or where there's a disparate impact theory, so where it's going to have an effect on one class of individual more than another class. How you would know whether agency action needs to occur or not, or the seriousness of it, the things you need to consider, or recommendations for the agency to act, would be in how serious was it? Is it a substantial injury? Is it a pecuniary injury? Does the discriminatory victim have an ongoing relationship with the recipient? All those would be factors you would consider when looking into whether there needs to be agency action or not. Okay, just skip one more, please, slide. Thank you. So the lack of states' 11th Amendment immunity under Title IX, Congress has abrogated states' immunity with respect to Title IX. The 11th Amendment bars state from being sued. Supreme Court held that it protects the state from being sued. However, federal courts have jurisdiction over the state where they have waived immunity or Congress has abrogated it. And in the case of Title IX, Congress has unequivocally abrogated it. Excuse me. The acceptance of federal dollars is a waiver of that immunity, and it outlines that here. The remedies are available at law and at equity. So the Department of Justice role under Title IX is to enforce Title IX, to coordinate federal agencies and that enforcement, and to provide representation for the United States and the funding agency. In interpreting Title IX, the department will look at and coordinate and consult with the DOE, which, as I said, I don't know what's going to happen now that the DOE is not here. The agency with the most Title IX experience and the agency with the regulations that serve as the basis for Title IX common rule. So in 2024, there was a an amendment put forth for Title IX by the Biden administration. And the Supreme Court rationale for Bostic and Clayton was what was used to base it on. It's not a new interpretation, but it's first time that explicit protection against sexual orientation and gender identity discrimination has been formalized in Title IX. And the rule specifically provided that schools cannot separate or treat any person differently based on sex in a manner that subjects them to more than de minimis harm. So what sections changed in 2024 amendments? And the next slides break that down. You have sex segregated activities and facilities. So under the new rule, transgender bathroom bans are prohibited, as are other blanket denials of participation. So if there is a blanket denial of some sort of participation, like no girls can play on the football team, only males can be in the male bathrooms, there's a blanket denial of a gender issue, then that would be banned as causing more than de minimis harm. That was in the 2024 amendments. Then this pronouns, repeated misgendering of a student or educator was seen as illegal sex-based harassment. And if any of you have dealt with these cases, you know it can be tough because teachers might know the student or whoever's dealing with the individual in the educational environment might know the individual as presenting as one gender. And now that has changed, and sometimes it's difficult, I think, for them to make those changes. Sometimes I think they're stubborn and don't want to make the changes. I just know that it's sometimes difficult to make that happen, injunction or no injunction. So pronouns were a part of this. School athletics were also a part of this. Or they were supposed to be, but they were left out. So the question was left open. So there was discussion about school athletics, but they weren't included. And then the state law was preempted, including protections against discrimination based on sexual orientation and gender identity. Schools have to comply with Title IX requirements, even if the requirements conflict with state law, and they can't have policies or practices that discriminate based on sexual orientation or gender identity. And once this 2024 amendment was filed, there were lawsuits filed in 26 Republican-led states. The protections for pregnancy and related concerns, concerns related to pregnancy, have been in Title IX since 1975, but they found that schools can't discriminate based on pregnancy or related conditions, and they called these not just childbirth, but termination of pregnancy and recovery. And the rule updates existing protections to include lactation as a related condition and to require lactation time and space for students and employees. New rule also contains provisions that apply only to students with pregnancy-related needs. So it's supposed to be specially designed for students who have pregnancy-related needs. Educators must also notify students of these rights and the way the rights have changed. So the Title IX coordinator needs to provide students with their contact information and advise them that the coordinator can work with them to ensure access and to all programs and activities. And that if the student is pregnant, or it's a pregnancy-related condition, that it will remain confidential. The rights that the student is supposed to be advised of, based on the amendment, was to inform the student about the school's obligations in non-discrimination and restrictions on disclosure of personal information, providing the student with the option of individualized, reasonable modifications as needed to ensure they can equally access programs and activities, allowing the student a voluntary leave of absence, at least for any medical necessary time and period, and ensuring access to a clean, private space for lactation. So those were the new rights students were supposed to gain. Employee rights that came as a result of this were similar, just expanding the break time for lactation and access to clean, private lactation space. Employees who needed a leave for pregnancy or a related condition, but who don't have the leave time and who don't qualify for FMLA, were supposed to be given voluntary leave without pay for a reasonable period. And school employees also have rights under the PWFA, the Pregnant Workers Fairness Act, and the PUMP Act. So underneath this particular amendment, the school's Title IX grievance process can be applied to all sex-based discrimination, not just sexual harassment. This means that schools can use the grievance process on all complaints of sexual discrimination, including those based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Any harassment based on sex, inclusive of those specific basis and retaliation, including peer retaliation. Grievances need to be in writing and incorporate due process requirements set out in this new rule. And so how did the law specifically change? Everything was broader in 2024. The definition of hostile environment harassment was defined in a broader way as unwelcome sex-based conduct. The broader obligation to respond to possible sex discrimination must respond to conduct that a reasonably person suspected was sexually discriminating. And employee reporting requirements need to be written and have to notify the Title IX coordinator. The protective practices expanded privacy protections, such as not disclosing to a parent of a minor if it was for the safety of a child or it was something that was deemed necessary. And supportive measures, schools were required to offer even if formal complaint is not filed. So the school is required to determine if there indeed is a need, that these patterns of discrimination or disparate impact are occurring, and if something needs to happen to address that, or supportive measures need to happen to address that, they're expected to take those measures with or without a complaint. So that was the broader 2024. Then in January of 2025, when Trump came into office, and I'm sorry, that slide is all mushed together, but he signed the executive order keeping men out of women's sports. That's what it's called. And it articulates the United States policy consistent with Title IX to protect female student athletes from having to compete with or against or having to appear unclothed before males. And Section 4 underneath the order, preserving fairness and safety in women's sports. Many sport-specific governing bodies have no official position or requirements regarding trans-identifying athletes. Others allow men to compete in women's categories. If these men reduce the testosterone in their bodies below certain levels or provide documentation of sincerely held gender identity, these policies are unfair to female athletes and do not protect female safety. So with this executive order, females are not asked to compete with males, and males are not supposed to compete with females, is how it reads to me, no matter what gender or sex they present as. And then following the amendment in 2024, there were numerous cases, as just stated, and all 26 of the Republican-led states. So I believe this first one is Maine. It's the MDOE. Yes, it is Maine. Maine will issue a directive to all public school districts requiring them to comply with Title IX and reminding them that noncompliance places their federal funding in jeopardy. The directive shall specify that Title IX compliance means that schools must forbid allowing males to participate in any athletic program or access any locker room or bathroom designated for females, and that meaning of words such as woman and man are to be understood in the context of the facts that these are two sexes. The MDOE will restore to individual female athletes all individual recognition such girls or women would have earned but for the recognitions being given to males who participated in girls' competitions. So if there's a male participating in a female competition, then their win would be gotten rid of or nullified, and the females would then be reissued some level of where they scored. The MDOE will rescind or revise any prior guidance documents or rules which permitted male athletes to participate in girls' teams and categories, and clarify that to the extent that state law conflicts with Title IX, federal law preempts state law unless the school district wants to lose federal funding. MDOE will require each school district in Maine to submit to MDOE an annual certification of compliance with Title IX and promptly notify OCR of any credible report that a school district is still allowing a boy to participate in girls' sports. So they're supposed to report whether this is being taken care of or not. So Maine is looking at, and these were the findings that I found recently, which I'm not quite sure. They're still going through these cases, but the law has completely changed. So I don't know if there are a whole bunch of new cases now that the law has changed, but these are cases based on the 2024 amendment. Maine lost their federal funding due to failure to comply because they refused to bow down to the Maine Department of Ed. The Illinois girls were forced to share a locker room with a student who identified as female, but was not female. So there's a case about that. In Tennessee, Biden's attempt to expand the Title IX was blocked by a federal judge, so there was an injunction. In Kentucky, Biden's attempt to expand was blocked by a federal judge. In Virginia, Biden's attempt to expand was blocked by a federal judge. In West Virginia, it was banned. It was blocked. Also blocked in Ohio and Indiana. In Oregon, the changes in the law led to a breastfeeding mother not being accommodated. I'm not sure how that happened, but the changes were for her to have a clean and appropriate spot to provide lactation breastfeeding for her baby, and that was, the changes didn't provide for that. So anyway, set to take hold in August, and expanded Title IX civil rights protections to the LGBTQ students. This is referring to Biden's changes. Expanded the definition of sexual harassment at schools and colleges, and add safeguards for victims. But then in January, the 2020 version of Title IX, which we've just gone through all of the components of it, is reinstated, and the executive order, which is referred to as no men's sports for women, or something of that nature, keeping men out of women's sports, was signed, and the Title IX was amended to change the word gender to sex. So throughout Title IX, where it refers to gender, should be sex, unless it's clearly referring to gender and sex in the same area. Okay, and that, I believe, sums up Title IX.
We do have a question already in the Q&A, but before I read the question out loud, I'm going to take this opportunity to drop the CLE code information into the chat and read it out loud. I'm also including the link for the materials. I already have copies of the slides in there. I will get with Dr. Brown and get that form, because I don't have that form yet, but I'll make sure to upload it into the materials. One thing that I'll do as well in the email that I send out to everybody, in addition to including the recording link and the materials for this webinar, I'm gonna go ahead and include all the links and materials for the previous three webinars, so you have it all in one place. So the CLE code for those that cannot access the chat, I'm gonna read it out loud. Is 25056955N. Okay, so it's gonna go out via email, and it's gonna be in the YouTube description as well. So let's see, we have one question here in the chat. It's like I think it's a four-part question, so I'm gonna go one by one. The first part of the question is, if the burden of proof falls on a victim of Title IX violations, what resources are available to young students lacking financial means to advocate for themselves?
Okay. Yeah, so and are we talking about minor students, or does it specify?
It mentions young students, or I guess both.
Okay. So anytime individuals need assistance with advocating, there are like legal services programs funded throughout the states. I hear Legal Services Corp might be something that's cut. I don't want to get off the path in discussions about funding and politics, but I'm hearing rumblings about funding. There are legal aid projects that do advocate for students who need assistance in education. Not every program in legal aid handles issues in education, but a lot of them do. There are also local advocates who are not attorneys, who provide assistance and are familiar with agency procedural fights. So they might file with the DOE, or they might, be familiar with filing with Office of Civil Rights and things like that parents can do on their own. Advocates sometimes are funded by grants, and they are on either a sliding scale or they don't charge. So that's something you can look for in your community. I know that a lot of times in rural communities, it's extremely hard to find help just because of lack of services. But frequently in the rural communities, there will be a legal aid that covers that community that does provide assistance, or there's some place like Southern Legal Counsel or some similar civil rights response to a need that exists in the state that would provide assistance if they aren't covered by legal aid. Does that help?
I will actually, we have a webinar on covering like all the legal aids and pro bono departments. I will also drop the link for the funding legal aid directory. Basically, you can find every single legal aid in the state. It provides a short description of what they provide. It has links to their website. You can sort it by state, by county, so that could be helpful. So there's an additional part to the question, which is also, can an educational institution enforce an NDA on a student who settles in order to benefit from any remedy or relief? Is there a provision to keep this information available to the public, like sunshine laws?
So if a student settles a lawsuit, there usually is some sort of agreement where I have seen levels of NDA attempted. If they're, I mean, contractually, I think they can. They're, I don't know to what extent you can disclose some and not all, but I do know that oftentimes we're trying to protect the student anyway because they're young, and usually there's some disabling condition when I'm involved. So where confidentiality is pretty key. But I do know that the school district attorneys will try to enforce some level of NDA against the parent and the student, usually.
I think the other parts of the questions were kind of answered already. If anybody else, we have like 3 minutes left. If anybody else has questions, feel free to drop it into the chat or to the Q&A. I will go ahead and drop the link that I mentioned for the legal aid directory, just in case anybody needs it. That will give people maybe a few seconds to ask questions. Over you go for legal aid programs. I just dropped the link for that directory in there. If anybody's on the meeting here and they're not sure, so always feel free to ask. It doesn't hurt. That way we have a better idea if what resources are available for your clients. All right, so I'm gonna stop sharing my screen. I don't think we have any pending questions. I see a few thank yous in the chat. And I guess this is the time, Bev. We've done 4 webinars already. This one was for 2 CLE credits, but I think when we add them all up, it's close to 5.5 CLE credits for education, for general CLEs and for education law. I feel like time was flying because I remember we were originally meeting with Glorian and planning all of this. I can't thank you enough for all the time and effort that you put in with all these resources, the slides, and the amazing webinars. And I also wanted to thank everybody that joined us for these webinars as well. So with all that said, Dr. Brown, I wanted to thank you again on behalf of the entire civil legal aid training community and the public interest law section. And with that said, any final words?
I just appreciate what you're doing, and anybody that can reach out and help you, I hope they do, because what you've set up is a wonderful mechanism for everyone to get what they need in the state. Oh,
Well, all right, everybody. I guess we're ready to wrap it up. I see a lot of thank yous and hearts coming up. So thank you again, Dr. Brown, and we'll see you all around. Have a great rest of
yeah,
your day.
sure.